Any mention? Item number 1.
Yes, Mr. Arpit General.
Yes, sir. Your Lordship, there are three issues.
This past last order, what have you done?
Yes, Your Lordship, there are three issues which have been highlighted and taken note by Your Lordship in the last order. First, with regard to satellite imagery, my Lord. Now, earlier NISAC said that it is unable to do it. Then the decision was taken in consultation with the committee that this will be carried out by Meghalaya Basin Development Authority. That was the fact which I apprised on the last date of hearing.
Yes.
Now, second thing is that, my Lord, we approached Meghalaya Basin Development Authority. It engaged this some agency. Then they require this safe file or KML data. KML data from the this is, Your Lordship will find in Roman 2 at page 2. Of the area, KML data format from the state government.
So we have to
Yes.
send the report
Sorry, report is not
this morning.
page 2, Your Lordship, kindly see page 2 of the report. So it is, Deputy Commissioner is collecting KML data, my Lord. Your Lordship will
What's
see.
KML data?
This is a KML data format, set save file or KML data format. The Deputy Commissioner has been directed, my Lord. And we will complete the survey of that.
Now you say that this order, our order was 28/10, but this order
Correct, Your
refers to 3rd October 2024.
Yes, my Lord. Then thereafter, 3rd October, we have asked the Deputy Commissioner. He is collecting the KML data. There is some delay, my Lord. I have also noticed that there is some delay, and
There's a huge delay then.
yeah, there is a delay, my Lord. That I admit, my Lord. I have also asked. There is a delay in completing it. Lordship, kindly give me short time, my Lord. We will complete it. So far as
Satellite imagery is not done.
yes, my Lord.
Then
Next is, my Lord,
coal mining in Southwest
there is not, as per the recent report, no illegal mining activities are taking place, my Lord. We have also apprised Justice Kataki regarding this, my Lord, alleged illegal coal mining in Southwest. That is there, my Lord. Third is, my Lord, Your Lordship has recommended, committee has, that is the bottom of the page 3, my Lord, where reporting.
1 second.
Page 3, Your Lordship, bottom last line, that no illegal mining activities are as of now taking place in Southwest Khasiel district, my Lord. Now, the another recommendation of the committee was that use of explosive for sealing the mine, my Lord. That was considered not suitable, my Lord, in the sense that
Why?
it will, because it will impact flora and fauna, and there are multiple huge mines in rat hole mines, my Lord, in the entire area. So they are looking for some other measures to fill it by sand.
How is it done normally? In other parts, how is it done to close abandoned
because
mines?
in the
even people don't fall into
they
those holes.
use the sand, and sand is ordinarily used, or debris is ordinarily used, because
See,
mostly
the
they
thing
are
is that in
open.
Bangalore especially they make these box cuttings, which
Yes, because I have
and
seen, my
and,
Lord,
and when the foliage grows around, it's very dangerous.
yes,
even for animals
so
and for
barricading has been, I am told, my Lord, previously I have submitted a report where barricading was directed to be done with regard to that.
people. We have to direct specifically for to do a survey of all these box cutted mines with drones and see whether
Yes, Sir Lordship, that will Yes, that
That
will.
is,
That is
because-
the area which we need to do something, because if one technique or one device is not correct, then we can do that that measure
No,
also.
but then how do you close these
Because
threshold lines?
what has happened, my lord, that
Because
there is
they're being kept open with.
no, there is a committee earlier. If your lordship will see, the earlier there was the committee consisting of the by NGT. NGT has supervisory committee, and certain measures have been suggested, my lord. So, because explosive is not the correct way,
No, I mean, what is the other way?
other way will be, my lord, filling up the pit by sand, or
By sand? How will it be filled by sand?
that is also a problem, because there we're saying that we need a huge explosive, my lord, because there are about thousands of mines in that area, in the entire district. That's a problem. That's a problem which committee is also committee suggested explosive.
No, normally what is done? I mean, in the normal
in
course of business, suppose the
the
mine needs to
open,
be closed.
what they do is that this is open cast mining, my lord. In other areas,
No, I mean, there are other places where they have this kind of tunneling
Yes.
mining also.
but in tunneling mining they close the pit head only, because entire pit head by putting some temporary measures, because here to in box cutting I have seen it goes 100 feet straight, my lord, and then they go in different direction. They go in different direction, because and their in tunneling method their ordinarily is a huge tunnel. Their tunnels are huge also, and they can carry the entire truckload
Where
of.
have you mentioned that?
Your lordship will pass page 4, my lord.
Page 3.
Page 4, Roman 2, my lord.
Yes. What is KML data? What's what's the full form of KML?
I'll find out KML. Save file in KML data, my lord. That I couldn't check it.
At least should have the courtesy to mention the.
Yes, full
correct
form.
nomenclature, whatever it is.
KML data?
Not just give the abbreviated form.
Yeah.
Not sitting here as experts knowing exactly.
Yes, yes, my lord. Oh, so KML stands for Keyhole Markup Language.
Okay, keyhole.
Markup language.
Keyhole map.
Keyhole Markup Language, and is a file format used to display geographic data in Earth browsers such as Google Earth,
Okay.
Google Map, and Google Maps. So
Okay, understand.
So this is the KML data. They are probably geographical terrain, geographical contours for that purpose, because spatial photography cannot be done.
Have adverse impact on.
Yeah.
Right.
My lord, kindly give me some more time to. We will come back with better report on this aspect.
Point 1 also.
Point 2
Point
also.
E also not satisfied.
Yes, my lord. Point 2.
B also no. Then
Setting of a smart integrated check gate, my lord. Now, because they have taken steps, my lord, on 20th number, along with they are
yes.
they are trying to identify in Rani Code PW to identify designated route where proposed smart integrated check gate will be transported to use.
A, B, C, yes.
Fourth is demurrage charges collected, my lord. What has happened, my lord? If your lordship will see the data, which is there at page 7. Page 7. Page 7 is tabular form, my lord.
Have they paid demurrage charge?
Yes, they have. Some of them have paid, some of them have not paid, my lord. And that is what your lordship will. If your lordship will see that total we have collected 5,61,865. Out on we have levied demurrage charge on 17. 9 of have paid. Then we have given.
What about those people who have paid auction money but not?
Yes, your lordship. That data
What happened to that?
your lordship will see at page 7.
Who have paid auction money? Not
Yes, my
lifted
lord.
the poll.
Now the problem is because of page 7. If your lordship will see page 7, the total quantity set up for auction at the bottom, your lordship, last column is 17. Then quantity we have the sold by MSTC is this much, my lord. Quantity paid by the for metric ton is this much, and mineral challan has been issued per so and so. And remaining quantity to be auctioned is
Re-auction.
yes.
This is for the people who have just paid the
the earnest money and
yes, and have not lifted.
yeah,
Have
lifted.
not come
Because
with the money.
what
What
has
about those people who have paid the money in full?
and then we are asking for demurrage charges. We are asking your lordship for because
But you paid auction in full.
yeah, what has happened, my lord, in the meantime, because of some situation in Bangladesh, Garo Hills, I am told that they have lifted the coal. So far as East Jantia Hills are concerned, they are reluctant to lift the coal because of disruption in trade activities, my lord. So that is the problem because of which the coals are lying in my coal depots.
Yes, yes, we are aware of
That is the
even in limestone, the rate has gone to
there is a complete disruption in trading activities, my lord, and that is why this problem has come. So far as Garu Hills are concerned, because they may be able to sell it in Assam and other parts, but here East Jantia Hill main market was Bangladesh, and there is a disruption because that's why data also showed, my lord, this sale is so much huge and lifting is even not half, my lord. And then in that case, we cannot take coercive measure immediately by seizing them. So some more time will be required, and we will continue to collect demurrage charges, my lord. And one or two cases, my lord, if your lordship will see, page 6 at Roman 2, that we have issued those who have not paid.
because Members Colony will tell you there's a case in this court also with regard that the
Yes, my lord.
it has
Yeah.
not it
No,
doesn't- it has
no,
not-
what has happened? That matter is not. I have gone through the file. It was shown. In that case, my lord, it was auction under Section 21 of the MMDR Act. Section 21 auction takes place under the order of judicial magistrate first class, my lord.
no, it has not lifted the court. That's
That
what-
person. So then again, if that person has not lifted the coal within time-bound manner, the state has or the complainant has option to approach the court once again by filing the application seeking permission to re-auction and forfeit his amount. That order can only be passed by the special court. We do not have power here. We have been given power by the court, but because this is a special arrangement of under the order of Honorable Supreme Court. That Supreme Court has made it clear Section 21 will apply, and we will have to follow the rigors of Section 21. The coal has been auctioned, the person is not coming forward. The
coal in auction, according to what was there in the file, was that coal is auctioned,
but
and the money has been paid to the government.
Yes,
but it's lying there.
So in that case, the only option is to approach the court once again. Either
approach the state.
State, because complainant is the state in that, and the court will, and by judicial order will pass the order. Either you re-auction, give last, like we are giving notices,
give last chance to people.
last
Because
chance.
you can't let the coal just lie around like that.
Yes,
for months on end.
yeah, and
after
that is possibility of pilferage and stealing will be there, and there will be. Otherwise, we have received the money in auction. That is there, but ultimately it is going to be benefit to none in the sense that that person has already deposited.
No, because of situation we understand.
Situation.
Because we're not getting
So
a good
if
price.
but for it will be the auction. It will be for the auction purchaser to come forward and move the appropriate application before the court, stating that some more time is required, and he will take measures to protect the coal from pilferage and stealing.
Okay, that's Section 21.
Section 21.
Okay.
So that is the issue where that is between court and the complainant and the auction purchaser, my lord.
Right.
So this is the current status, my lord. We are continuously apprising Justice Kataki about.
But it's sad that it's not moving anywhere.
Yes, my lord. There is
And
this
the
report.
scope of,
I am also not satisfied. Especially on two counts. One with regard to the survey, my lord. That technical details should have been collected and exercise should have been carried. So far as demurrage charges are concerned, my lord, steps have been taken. Auction lifting of the coal is concerned, your lordship is aware that because of ground realities, it is not being lifted, my lord. And so far as we have
that mine closing, then you have to come with, there must
with
be
some better measure.
32,000
Yeah, my lord,
open mines in each
in
area.
that is the because I have personally
They
gone
can be reactivated within
in
hours.
no time. And Sutnaga area I have already seen. My personally also I have gone that
This
it
is
is
digging again now.
yeah, that area I have seen. So we will kindly give us some more time, and we will immediately on reopening, my lord, we can take our first week of February, my lord.
Can you give us an interim sales report on 17th?
I can do that, my lord.
And the 26th interim report been filed by Justice Katiki committee, which will hand over a copy to you. I mean, you can obtain a copy.
Yes,
and
ma'am.
this is not very happy with the situation.
Yes,
The
Milord.
thing is that before the next date, if we can't, then we'll have to pass some orders which may not be the liking of the
No, no,
administration.
Milord, we will take measures.
Regarding the deputy commissioners, with regard to what they have to do.
Yes, Milord.
We don't want those.
Yes, Milord.
Those
I
orders to
understand, I
come.
understand.
And if
But
it-
I understand. Justice Kadaki is also trying his best.
yes, take down
Get the
a
report.
status report on behalf of the respondent state has been filed today. Specifically, this is compliance to which?
This is the compliance to 24th and 25th.
Yes, this is important compliance to the 24th and
25th interim reports.
Interim report of the Justice retired Katiki Committee. Stop. Next para. While referring to the report, the Learned Advocate General has submitted that the suggestions and recommendations made in the interim reports, apart from demurrage, have not been carried out. That is satellite imagery, number one. Number two, and for the closure of mines to stop alleged illegal coal mining in southwest Gare Hills. He submits that regard to demurrage, the same is being put into action. The regard to the levying of demurrage charges, the same has been put into action, but he submits that due to the political climate in Bangladesh, the coal, a huge amount of auction coal is yet to be lifted for by the auction purchasers. With regard to the status of inventoried coal, it is seen that it is shown that the transportation for entire inventoried coal has been completed. Stop.
From
Yes?
Pithead to the coal depot.
From Pithead to the coal depot, right? Has been completed to coal depot. Stop. He, however, praised that due to the delay in implementing the other recommendations, perhaps the state can be given some more time to complete the same. Stop. The submissions are noted. Next paragraph. The Justice Category Report Committee has also filed its 26th interim report, wherein in the summary of recommendations, the commission and recommendations has touched upon the areas which the state respondents are yet to comply with. A copy of the interim report be made available to the Advocate General, who shall file a interim status report on 16th December 2024 before court closing. Yes. Status and compliance report by 16th December before closing to allow this court to pass further orders as necessary. This accordingly on 16th December.
Item number 2.
There are two PILs, my lord, tagged. That
Lordship, my only prayer today, Lordship, is that there were some orders that the private respondent, this particular company, they have deposited the challans and all in the registry, and it was required to be verified in the presence of the advocate, but they are not being represented for the last few occasions.
Who?
The private respondent, Jema Cole.
So what to do?
If I may pray, Lordship, that the Lordship may pass an order that it should be represented in the state of Assam also, then probably we can move forward with the...
It is submitted by Mr. S. Dev that there has been no representation on behalf of the private respondents. Number
8, Lordship.
number 8. Since
I'm sorry, number 14. Number 14.
number 14. Since when?
Last 3 or 4 occasions or since August.
The last 3-4 occasions. Stop the court. The court notes the same. We expect in the next date that there should be some representation on the part of the state of Assam and the respondent 14, feeling which other orders will follow. Yes.
Item 3 also
Item
is a
three?
Same.
Yes, together with some. Yes.
Arrange the
Pronouncement of judgment. Item number 1.
Therefore, in the considered view of this court, the SOP, which was notified by the impugned memorandum dated 5/3/2021, does not suffer from any lack of jurisdiction or is incompetent in any manner, as the same has made in furtherance and compliance with judgment of the Supreme Court in Aldimasa, stipulations MMDR Act, and the mineral concession rules, and as per this direction of the Ministry of Coal. The other submissions of the petitioner with regard to provisions of the Meghalaya Mines and Minerals Policy 2012, the Meghalaya Minor Rules 2016, also the Meghalaya Minerals Prevention Legal Programs are disregarded as they have no application relevant to the issue at hand. Accordingly, there were merits dismissed.
Item number 2.
Coming to the main aspect of the matter, it's noted that the mismatched uploaded PAN card number was the one alphabet, which at clause 23N is listed as a non-rectifiable deficiency. Though in the judgments placed by the respective counsel of different high courts, there have been divergent views. This court, in consideration of these pronouncements, also circumstances of the case, would hold that the petitioner, while applying for the RO dealership, was well aware as to the undertaking which had been given at the time applications for retail outlet. At clause 15A of the application itself has been clearly spelled out that it was found that information given incorrect amongst other conditions, then the candidature would stand cancelled and declared ineligible for retail dealership. Further, though it has been argued that the brochure for second dealers is only a guideline which does not have the force of law, the fact that PAN card number mismatch being listed seal number 23N of the list of non-rectified deficiencies in applications, the considered view of this court, this requirement which binds a petitioner in no unclear terms, despite the fact that the error was of single alphabet, will constitute an infraction of agreed terms and conditions. It's also to be noted that these guidelines have been framed and are part of company policy, which the respondent company is also bound by. The decisions placed by the petitioner of the Karnataka High Court, therefore, will not come to his aid, most so as the same that dwelt in detail or as to circumstances allowing the petition. The other point that go against the petitioners also that the fact that no challenge has been made to clause 23N, and as such, notwithstanding any other circumstances, the petitioner is bound by undertaking within the application. The decisions placed by counsel of so are not elaborated upon. However, reverting back to suppression of material facts by the respondent company, which it appears has been made knowingly in judicial proceedings for this court, the same deprecated and expected the necessary appropriate disciplinary action be instituted against officers concerned who are responsible for misleading the court. It's very important that, and we will follow it up. It's also provided that the response 2 and 3 for such conduct shall pay a cost of 1 lakh to be made over to the state legal authority for a purpose of legal aid within a period of 4 weeks from the date of this order. Yes. See, you can't mislead the court. Although in law you had a good case, but misleading the court, other things. Yes.
Any mention?
Let's crave your lordship's indulgence with a very unusual request. Let's WPC number 339 of 2024 is listed as item number 9, my lords, tomorrow the 3rd.
In the weekly list.
In the weekly list, my lords.
How do you mean it?
Well, there is some personal difficulty. I've requested my learned senior friend, the Advocate General, who's appearing for the MECL as well as the private respondent. This is that, my lords, electricity-related matter.
Tariff matter, my lord. Which
your lordships have fixed. I was praying if your lordships would kindly accommodate us on Thursday, my lords.
But why mentioning today? Mention tomorrow.
Well, there's some personal difficulty, my lords. I'll not be here. That is the only reason, my lords, I'm craving. We'll renew our prayer again tomorrow, my lords. We'll renew our prayer. Obliged.
Please, Lordship. Lordship, I'd like to mention item number 23, Lordship. Lordship, this matter may come out after vacation, Lordship.
Is it fructuous?
After vacation, Lordship.
Where's the other side?
Lordship,
You informed him?
I will inform him. I've been looking for him,
Will
Lordship.
not work.
Lordship, I've been looking for him outside. He's not there, Lordship. So, I'll inform Lordship.
Will call it out. Let him be, because he will not be aware it's been adjourned. You wait there. Yes. We have to maintain certain, consistency.
I've been looking, Lordship.
Yes.
May it please, Your Lordship. Your Lordship, I beg to make a mention of item number 26, Your Lordship. I humbly pray, Your Lordship, kindly this matter may be listed after vacation, Your Lordship.
Yes, Mr.
I have no objection, my lord.
Yes.
3 to 18, there's a stay order in their favor, Lordship.
So you wanted her before vacation?
Possible, Lordship. It's a short issue of they have got
The appeal is pending before the district council. This order.
Where's Mr. Mumin?
Lordship, his son is not well, Your Lordship.
We'll have it. We tried now second next week after 1 week. Yes.
Interim order may be continued, Your Lordship.
Interval will continue till next week. John Fon.
Your
Yes.
Lordship, I beg to mention item number 19. Kindly let this matter come after vacation, Your Lordship.
Other side is whom? Dr. M. Muzika.
There's not time only to play some judgments, my lord, and that's, I think, 3-4 months now.
3-4 months look for judgment. But there's no interim order, correct?
There's no.
22 matter. Next vacation, it won't be for the bench anymore, yes. List after vacation on the request of the consulted petitioner. Yes.
Well, item number 25, my lord. We have received a call from the petitioner, my lord. He was appearing from out of station. The link, some problem with the link. He's praying for it.
Manan Sarakar.
Yes, my lord. I'm for the respondent, my lord.
Okay, you take submissions at the bar after vacations, yes.
No, my lord. He wanted it to be on Wednesday, my lord.
Wednesday?
Yeah, my lord. When it's on next week, let it be next week.
No adjournment. Any adjournment now? Only in special
No, he's not
circumstances.
adjourning me, my lord. I was supposed to produce the record. The record is with me, my lord. Actually, he's not getting the link. That is, he called me and he made a.
Who's the local counsel? You're there?
No, my local counsel, my lord.
Oh.
So let it be next week, my lord.
Okay, after 1 week.
Hello.
May please, Lordship. Lordship, I'm beg to mention one for urgent listing, Lordship. In fact, this was mentioned in a Friday. Due to some difficulty, same has not been listed in the course list. This is a case pertaining to a student, Lordship, where he just secured 60% of attendance, and the institution is not allowing him.
Why is it listed? Was it allowed?
Yes, the filing has been done this morning, Lordship. The end
Why
of the
did you file last Friday then?
due to some difficulty, Lordship, it was not able to file. Therefore, Lordship, filing has been done. So I pray that it to be taken in the end of the board, Lordship.
You can't file it, you'll come tomorrow.
Because, Lordship,
Tomorrow last day.
because the exam is going to be held on 6th, Lordship.
2 days?
Today is the second.
But the exams, you have to get your clearance from NEHU, correct?
Yes, Lordship.
Even the college, if they are to condone whatever absence,
Yes.
that has to go from the college to the university authorities, who will then allow examination, whatever the control center.
Yes, Lordship. In fact, he has done representations.
What is the
Due to,
reason for his
medical,
classes?
Lordship? He has undergone the this surgery as well. Therefore,
Has he furnished his medical reports
yes,
for
Lordship.
consideration by the college?
Yes, we have, Lordship.
The college rejected it.
College rejected, sir. In fact, they are not taking his representation as well. Therefore, Lordship is
Okay, you get it listed, yes. As a student.
obliged, Lordship.
But it has to come now only.
Wait, please, Your Lordship. Your Lordship, I beg to make a mention of item number 20, Your Lordship.
On whose behalf?
Mr. A.G. Momin on behalf of respondent number 4, Your Lordship.
You're for the petitioner?
I'm for the petitioner, my lord.
This is the matter that...
Yes.
Unauthorized construction that...
then what, we're waiting for what? Only the last
Inspection report. We have the
Yes,
inspection report.
Let it come. We'll take it up. You wait here.
Lordship, the conducting counsel is not here, Lordship.
Doesn't matter. You're always here, so fine. We'll see. If any orders necessary, we'll see. We'll examine the inspection report. You wait, yes.
Right, my lord.
Yes.
Your Lordship, Your Lordship, I beg to mention item 21 and 22. Mr.
Number?
Pathak, 21 and 22. Mr. Pathak is having difficult personal difficulties. Mr. Pathak.
We'll go after vacations. Yes. After vacations?
Yes, Your Lordship.
Okay.
Item number 3.
May I please, Your Lordship? Your Lordship, this is a contempt petition against this Honorable High Court's order dated 25/4/2024, Your Lordship. The order is at page 8, Your Lordship.
He has not processed within 12 weeks.
No, Your Lordship.
Okay, it's heard MS Akashi. Issue notice returnable in 2 weeks. You have to give a receipt AD within 3 days. Yeah.
I'll be obliged.
Item number 4.
My lord, I pray for withdrawal of this with the liberty to file afresh.
Let him withdraw. Let the records be straight at least. Yes, Mr. S.M. Suna submits an instructions and we will have to withdraw this straight application. However, liberty to file a fresh to advise. Stop. Prayers allowed. Matters claims on withdrawal. However, liberty is prayed. See, one line can make such a whole difference. That's why,
I've gone through, my lord.
That is the thing, and as a lawyer's work, you have to be very careful about even a comma also.
Item number 5.
Five and 6, my lord, both are relating to boundary dispute, my lord. Now, matter came on last week on 27th November, my lord. Final hearing date has been fixed for 15 January in this matter, my lord, by the Honorable Supreme Court.
What this matters before by whom? Who's this New Year here?
There is there are 3 petitions, my lord. They've directly also filed newly.
Boundary dispute.
No, regarding the Assam Road Transport Corporation occupying the land of Nearly, thank you, my lord. So he filed a writ petition 672. In the writ petition, direction which was sought, my lord, was direction to state of Assam and Meghalaya to demarcate the boundaries.
What was the other one?
And the other one is, my lord, if your lordship, other one was the order with regard to the writ which the SLP 1685. Yes, my lord. This which
was filed by the state.
Yes, my lord.
That's the one. Yes, where's the order?
Yeah, Hamberley, my lord.
Yeah, that is what this court wanted. I was wondering what. The Advocate General has produced copies of order showing that the connected matters have been fixed before the Supreme Court for hearing on 15th. This is after 15 January 2025. Only this is matter after 15 January.
After vacation?
After vacation, 3 weeks after vacation.
Item number 6.
Same order, my lord. 6 is same.
Seven.
So you'll be trying to resolve this matter, my lord. I may pray this matter may come up after, my lord, for allotment of the shop.
Why didn't you go to get your shop then that time when all the others went?
No, we had gone, lordship. They had extended a letter also that they will do it, but they have never done it.
No, that's not true. They were in fact sitting in the meeting. I was there myself. He only represented 2 shops. He did not tell us about the 3rd shop. We could have settled it right away. So we are trying to work on the terms of the settlement, if at all.
You can't hide things, obviously.
No, lordship. There were 2, because that shop which we are concerned with now, that was pending litigation. It is still pending litigation. In the meantime, they wrote a letter to us that you withdraw all that. We'll try to extend an agreement. So,
does this order of this court cover the 3rd shop?
No.
No. This is only with regard to a representation.
Lordship.
Oh.
So even I'm on instruction that they are trying to. So let it be listed after
the vacations, my lord.
After vacation, the request of the parties.
Obliged.
As the matters under restitution is.
Item number 8.
This is that contempt matter, lordship, regarding nectar, lordship.
What's happened to this?
The last.
But I've been asked to enter appearance.
Yes, Dr. N. Mozika today has ended appearance with so-and-so. The parents, we have how many respondents?
1 and 2, lordship. 1 and 2, lordship.
1 and 2. Please follow up 3 weeks' time to file affidavit. Yes, this is thereafter.
8 and 9.
8 and 9 are connected.
Item number 10.
Lordship, in this matter, reply on behalf of respondent number 4 will be filed during the course of the Lordship. It is being filed now.
No objection, Your Lordship.
Yes, Pandey submits that the affidavit behalf on the full fan course of the day. This file rejoinder?
No, Your Lordship, we won't file.
No rejoinder?
No, Your Lordship.
You already got a copy of the affidavit?
No, Your Lordship, we have to proceed.
And how do you know you don't want to file rejoinders?
Because it's teacher's matter, Your Lordship, we wouldn't be filing rejoinder,
Yes.
Your Lordship.
After vacation of hearing.
On by Lordship.
Item 11.
Do we file our affidavit?
This can be posted for final hearing, Lordship, after vacation.
Parties submit appeals complete. This matter for final hearing after vacation.
12.
So here in this matter, I'm praying for 1 week's time to file our rejoinder, Lordship.
But the contract has already been executed, my lord.
But we have instructions, Lordship, to pursue with the matter, Lordship, because they are
So
serious.
the thing is that if you have the
seriously
civil
Lordship.
remedy, if the contract is executed,
Let us take
Yes.
instructions then in that.
Then
They don't meet the requirement, my lord.
Our
whatever
case is
it
that,
is,
Lordship,
no,
we
I mean,
meet
they
the
give the-
requirements, Lordship.
contract for what? For construction now?
It is to supply you X-ray machine for
X-ray machine,
operation
grievance.
theatre.
X-ray machine.
Lordship.
That is already supplied.
Already supplied installed.
Then
We'll take instructions, Lordship.
tomorrow?
Next week, Lordship.
They are,
After
this is the matter after 1 week, yes, to allow the petitioner to obtain instructions, as much as been reported by the learned DSGI that the contract in question has since been executed by the private respondent. This after 1 week, yes.
Item 13.
But here I'm praying for some more time. Even the state is not valid.
State has filed. Respondent number 1 and 2 has filed the affidavit. 3 and 4, Lordship.
What about respondent number 3, entering appearance? Who number 3? Three is GHB India. Number 4?
I'm for 4, my lord.
You're for 4.
Number 3 may not be interested, my lord.
Because he is not a successful bidder, my lord.
You will strike him off.
Lordship.
Mr. S. Chanda, Learned Counsel Petitioner, submits that though respondent number 3 has been served, but it's on to serve the same not being successful bidder, he may be struck off from the array of parties. Accordingly, the same is struck off. Stop. Dr. M. Mozika, the so and so.
What is point number 4?
Pray for how much further time? 2 weeks to file
2 weeks time.
affidavit.
We may be allowed to file rejoinder to the affidavit filed.
Rejoinder permitted to file against the if it is filed by respondent 1 and 2. Based on so and so, yes.
Item 14.
Respondent supervisor.
Where's the respondents? What's the matter about?
About the petitioner was removed from service.
Who's the respondent?
For the state lordship.
Yes, where's the affidavit?
Lordship, we have already sent the notice. We are yet awaiting for
Notice to
instructions.
whom?
If your lordship may. Yes, it is addressed to the state respondents, lordship.
No, it's
Number
notice sent by letter. You don't call them.
So we have sent the WT message. We are yet awaiting instructions. We'll file it.
We have no objection to the cause title. Anyway,
No, lordship.
let them take more time for affidavit. Yes. 2 weeks time as period allowed to respond to the affidavit. List thereafter and so on.
15.
Yes.
Lordship, 15 and 16 are connected. Connected matters.
Yes.
Connected.
17. 16. Sorry, 16.
Your Lordship, you have taken steps regarding to the service notice.
I'm entering appearance of the respondent number 3,
You have 4, 3 and 4.
3.
4 is whom?
4 is
4 is?
Headman.
Headman. Village.
They've been served. Which village is this?
Village is Mautlong Mensan village.
Number 4 is the most important respondent here.
Your Lordship, in the last occasion, Your Lordship have told me like that I should have enclosed more, means the document is more convincing to the court. I have some photos, other photos, if Your Lordship allowed me to bring on record traditional affidavit.
You've been ostracized?
Yeah, I have been ostracized till now. No document is being, not even a residential certificate to my family is being given.
No residential certificate?
No residential.
What do you need it for?
I need residential certificate sometime in the school or in EPIC and others. And other activities also I'm being boycotted. Not allowed to take part even in the Dorbar.
Mr. W. Jurwat and parents in behalf of number 3. However, though Mr. Dukrut submits that the respondent 4 has been served, where is that service? You've obtained status?
Yet to, I've not
Sir.
My lord, the entire pleadings has been misplaced, my lord, in as much as in the cause title have been pleaded as respondent number 3, whereas in the entire pleadings have been laid as respondent number 2. Annexure 17 is also missing, my lordship.
What is this, Mr. Dukrut?
I will check to
check what? Let us see where you say what?
From paragraph 2 onwards, my lord. And in the entire pleadings.
You be careful with the pleadings. It is para 2.
My lord.
No, para 2 it says Williams for number 3.
I received.
Oh no, number 2 is William. And for number 3 is para respondent.
And
So
the entire pleading is it has gone by that way.
So
there is some mistake in typing.
Some mistake is a big mistake.
Kindly allow dial do some correction.
What correction? You have to correct the entire petition. Annexure 17 page. We permit you file afresh two documents properly. Page
55, 56.
This is the problem here.
Whereas in paragraph 13, as the date has been shown as 5th of June 2023, Your Lordship.
This is 11/8/23.
Whereas in the pleadings at paragraph 13, it has been different document, Your Lordship.
At paragraph
13.
See, Mr. Dukrut, what happens that your clients suffer? The clients, people come to lawyers to expect, good, legal service. You're in the service providing industry also.
That's true.
They expect good counsel.
That's true.
If from the fault of lawyers itself, the cases get spoiled. Paragraph
13, my lord.
We're going to see relentless protest petition should do this. 5th June. 5th June.
Whereas it has been the annexure is 11.
Annexure 16.
Document.
Annexure 16.
No, no. 31.
Page
53.
You prepare a petition yourself.
Actually, I did the drafting.
Subcontracted someone else.
No, my lordship.
Then?
I did the drafting, but I allowed my associate to.
You have to teach them the basics, no? This annexure 13 is some letter there 31st March. And in your annexure refer to 5th June.
Withdraw, file fresh.
Allowed me to.
We'll impose cost, I think.
Can you allow me
Make you
to?
more alert.
No, Your
To be paid by the lawyer, not to be paid by the client.
Your Lordship, kindly allowed me to withdraw and I file afresh.
Even the translation is wrong, but you withdraw.
See, this is what happens. It's this person's genuine grievance.
Yes.
And because of, the, what to see also, after hearing it sometime, when the matter is taken up, just take them, Mr. Peter Crut is not to withdraw the incident petition, will liberty you to file afresh due to the serious defects that have appeared in the pleadings. Stop matter sample withdrawal with liberty, however, liberty as prayed.
17.
Lordship, here consequent to order dated 14/11/2024, we have approached the bank and we have written a letter to them with regards to. Lordship,
One second.
Lordship, this is that matter where the bank had issued a surprise notice for seeking possession despite me servicing the loan in the name of my late husband for the last 4 years. So accordingly, Lordship, on the day of motion, Lordship had also allowed us to approach the bank. Lordship, order dated 14.
Yes. You are appearance of the bank.
No, Your Lordship, we have ended 4, 5, 6, 7.
I'm appearing for respondent 8.
So what happened when we went to the bank?
Lordship, we had written 2 letters to them. Accordingly, on the 22nd, bank wrote a letter to us asking us to come and meet physically. If I may, Lordship.
Number 3. That means you're number 8. Who are you?
He's the second wife, Lordship. Lordship, this is in continuance to 2 letters we wrote on the 14th and on the 19th. Accordingly, on the 22nd, bank wrote to us asking us to come and meet them. We went on the 26th. We had a meeting, Lordship. The meeting.
You already initiated surface of proceedings, like you said last time. What
Lordship,
is in this letter?
Lordship, Annexure F. This is on the 22nd they wrote to us. After we wrote 2 letters to them. And accordingly, we had a meeting on the 26th. Post which, Lordship, they asked us to file a written proposal, which we have already took today. Certain changes have been directed to us to be done by the bank. Accordingly, we have submitted a proposal, Lordship, today, so they will.
Your Lordship, but they're not the guarantor, Your Lordship. They're not the guarantor, Your Lordship. First of all, they're not guarantor.
You are whom? You are?
A private respondent 4 to 7, Your Lordship.
Oh, I thought you for the Accountant General. Yes.
Your Lordship, they're not the guarantor. First of all, and second of all, they have forcefully collect the rent from the property. Forcefully, Your Lordship. Yes.
Have you filed complaint against that?
Your Lordship, we have taken some steps, Your Lordship. Third of all, Your Lordship, they are nowhere mentioned as the. They're nowhere mentioned.
Oh, you're Jonita, Mary Nongrum, Jonita, then Cynthia Nongrum, Wilbert Nongrum. These are mother and children.
Yes, Your Lordship.
She's the first 5 and their children, Lordship.
Yes, Your Lordship. She is the guarantor, Your Lordship.
He is a guarantor.
She is a guarantor.
So the loan's against you.
Yes.
Are you servicing the loan?
Your Lordship, they're collecting the rent. From where will we? How will we pay the money back to the rent?
Possession of the property.
Possession of the property, also, Your Lordship. They're forcefully taking the rent.
Lordship, we are not forcefully taking the rent for the last 4 years.
I don't know now in writ proceedings, and you are number 8. You have nothing to do. Nothing.
Basically, no role, Your Lordship. Let us file a power. We'll file affidavit, Your Lordship.
Let them file affidavit. Lordship, I have a limited prayer, Lordship, at this stage. Since my proposal is there, so pending adjudication upon the proposal, courts will go into a vacation now, and we are also in a title suit.
Now that NPA of that property itself, that will service it'll service more than the debt is outstanding, I think.
Yes,
the property will service, Lordship. At least, Madam, at least 5 times more, minimum. The question here is, Lordship, that I have been servicing that loan account since 2020.
The property in whose name? Is your name?
No, it is in the name of my late husband. It is in the name of the late husband. They might be guarantor on paper. I have been servicing the loan. There's a title suit pending.
No, we
Lordship,
understand. We understand.
in their interest and my interest, collective interest.
Let the property be sold if it's like that.
Yes?
If it's like that, Your Lordship, let the property be sold, Your Lordship. Let NPA take.
Take down.
No, they cannot force
has entered appearance today on behalf of respondents number 4 to 7 and Asia on behalf of respondent number 8. Stop. What about steps on 2 and 1?
We have taken on all, Lordship. In fact, the bank acknowledged to us.
Appears on behalf of respondents 1, 2, and 3. Stop. This is matter of it is next matter. It's submitted by N. Khera and counsel with the petitioner that as allowed by this court by order dated
14/11.
14/11, the writ petitioner has approached the bank and certain talks are going on.
They asked us to submit a written proposal, Lordship.
Proposal for liquidation of the outstanding dues. MS Ibipasa, however, submits that the respondent number 4 is the guarantor, as the property belonged to her late husband. Next one, be that as it may, let an affidavit, find out within 1 week, list this matter on, after 1 week, for further orders.
Highly obliged.
Hearing, item 18.
Please, Your Lordship, let the matter be taken up at the end of the vote.
Or the end of the vote now?
Yes.
May it please Your Lordship. Lordship, I should begin with an apology, my Lord. The conducting counsel, Mr. H. Kamalang, is indisposed, my Lord.
What is wrong with him? I think he has more absent days than days. He has to look after his health properly. What is responsible position? Court work can't be held up just because of, all the time unavailability.
Alternative, because there are so many panel lawyers for the government, and it's all.
Well, he's conducting the case, my Lord. That's the.
Doesn't matter. Two appearing, I see, in every case, even though they're not senior also. I don't know in which way they're appearing, assisting each other. I just hope it's not a, burdening the state exchequer unnecessarily. Yes.
Mr. Paul also is not here.
Where's Mr. Paul? He was here? What was it for today?
It's for the petitioner to satisfy this court regarding 3 points. One is that the appointment letter of the private respondents has not been challenged. Secondly, the rejection of the MPSC of their candidature also has not been challenged. So no effective order can be passed by this court.
So, my Lord,
because then he becomes ineligible. A lot of person who is ineligible cannot challenge the appointment.
Was rejected by the MPSC.
My Lord, it is, may I just submit, my Lord? Now, the first objection that they raised was that the appointment order of the private respondents were not put into challenge, my Lord. Now, my Lord, at that relevant point of time,
it was not out yet.
When I have challenged the select list, my Lord, that is a select list. So I have challenged the select list, my Lord. And appointment order was yet to be issued at that relevant point of time, my Lord. Now, but today, my Lord, as the picture by the respondents, my Lord, my prayer has become infructuous, rather. There is no effective order cannot be passed, can be passed, my Lord. In my humble submissions, my Lord, that wouldn't be the case, my Lord. Why that wouldn't be the case? Because, my Lord, the appointment order has its root at this select list, at the order, my Lord. So if that order, if my Lord declares...
You're trying to advance your case that whatever happened, it is consequential.
Consequential, my Lord.
Consequential orders also will go.
It has to go all.
That you'll have to,
Yes.
And the other part regarding rejection representation, and you're not in contention at all.
Yes.
So it doesn't mean that if, like the representatives allowed that you'll get employment. You'll be out. What is...
No. My Lord,
in fact, he's not asked for, he's just asked for setting aside the... not for appointment.
In my petition, my Lord, in my...
there's a select list, entire selection.
Yes, the select. So, my Lord, in my, whoever was selected, my Lord, both are here, my Lord. 2 posts, 2 persons selected, all disqualified, that is okay, my Lord. But here, my Lord, my intention is not that, my Lord, set aside their appointment orders and appoint me in their place because I am more qualified.
You want to set aside the entire selection process.
Yes, my Lord. Yes. So there has to be a re-advertisement to this, my Lord. This is what I am contending for, my Lord. When, my Lord, here what I am saying is, my Lord, what is my locus, my Lord? When my locus is this, that I was also one of the candidate, my Lord, for the post, my Lord. But I am not much aggrieved because I was not, I did not have enough qualification to be selected at that point of time, my Lord. That is not my grievance, my Lord. My grievance is that when a person who has got less experience than me, gets selected, my lord, gets appointed, my lord. And when, through documents, when I know that the documents that was submitted before the authority, my lord, these are forged documents, my lord. These are manufactured documents, my lord. So this is where
How do you base your allegation that they're forged
allegations, my lord? I have the proof to show, my lord. I can show 3 pages is good enough to 3 documents good enough to show, my lord. If they are ready
forged
to,
documents?
yes, my lord. If they are ready to.
How important is the government?
In fact, my lord,
Can the matter be carried on without the state respondents?
in fact, my lord, here, even the state respondents, they have not made the main respondents, the Bharat Scout and Guides, also a party.
Mr. Guru, why?
That is the...
My lord, I don't know why, but I understand, my lord, when
don't know why.
When the
Not
things.
asking why.
No, I just asked my question to myself, my lord. When
No,
such.
ask question to you, not for you to ask you. If you answer, you ask on yourself. Answer it yourself then.
My lord,
It's like that.
my lord, I have no doubt in my mind, my lord, when the serious allegations has been raised, my lord, lots of technical hurdles will be created, my lord. But then, my lord, the facts will remain the fact, my lord. I'll overcome one by one all the hurdles, my lord. Who publishes the advertisement, my lord? MPSC.
No, I'm asking, is the government necessary party that we proceed?
Government is a necessary party.
My lord, because inquiry, because in the prayer, my lord, direct respondent 3 to conduct an inquiry, my lord.
If only
When
one.
Mr. Karwan will come tomorrow.
Lordship, I will seek instruction.
If only one, even if the respondents, they claim themselves to be very clean, my lord, let there be an independent inquiry. Let pending, my lord. Let the support be.
Cross the first hurdle.
My lord.
Asking for a gold medal. It's like that. You
No,
know.
no, my
The
lord.
career has not started as yet. You know.
My lord, no, my lord. So,
just after 1 week, yes.
1 week.
Yes.
1 week.
You have to understand where you stand, so means you open. You can't expect, you know, that you're still in the starting block and you say like that podium.
My lord,
I'm going to
this
stand
case,
there
my
number
lord,
one.
this case, my lord, I've never been more confident in this case, my lord.
No, I like your spirit. You got all cases.
Obliged, my lord.
Yes.
20.
Where's the joint inspection report? Who sought time today?
Copy of the thing.
Or Mr. Moomin? Mr. Moomin aspiring for whom? Number 4 is? Oh. Mr. Shongwan, you received a copy of this?
No, my lord.
You were there?
No, my lord. I have received just now.
Hmm. Where's the joint inspection report?
So the inspection report is this, my lord.
Number 3. Who was there?
Kindly see page 2, the attendance sheet, my lord. The type copy is at page 3.
Oh, yes. Now these are all houses Shoko has been issued to.
Yes, Lord.
Where's Mr.
Number 1.
Shongwan's house?
At page 4, number
This
1.
one's client's
Sirpai
house, sorry.
Stunga.
This one Sirpai Sutunga. Yautume. Semi RCC.
I have this one confusion, my lord. Can you see the 6th row? Building permit. So as per this report itself, it says there's no building permit. Now the question is, who are they supposed to obtain the building permit from? And my lords will see right on top, it says details of households at so-and-so, outside Joy master plan area.
And where are they
So
going
there
to
is
get
some
it from?
confusion. Now, lordships will recall on the last date, there was this, KHT had produced a notification. So as on 15th April 21, it appears the autonomous district councils have been authorized.
That means the orders come from the incompetent authority.
No, Manoj. The building permission would come from JHADC.
Exactly.
As far as the question of stopping any unauthorized construction within the river is concerned, within the river banks, that is under the directions of the NGT.
No, where's JHADC? What do you have to say? But you don't know where to get permission from also. Has it been widely publicized that you get a permission from JHADC? No, but will the people know? Awareness is the basic thing and everything. You know, that is people should know. He had his permission from Bashnong happily even and made his house. Whether it's crooked, whether it's straight, whether it's 10 stories, his permission has been granted.
We were not under the knowledge because we had only issued a landholding certificate.
But do you have any implementing agency?
No, I'll just point out, please see my affidavit filed on 13/4/23.
Yes.
Page 13, the minutes of the meeting which were held in the DC's office. At serial number 6 in the minutes of the meeting, it's recorded that a decision was taken that all the localities of Juwai should be informed about non-issuance of NOCs. And this was, the idea was that the stakeholders would spread this information. And one of the stakeholders were the Dorbashangs themselves. So steps have been taken as far back as 2017 itself by the DC.
See, people who build the houses, laborer, only one teacher. Septic
No, it's laborers, these are actually tenants. They're not the owners of the property.
No permit, yes. No, plain area. But that time, see, Mr. Shongwan, only your building was still under construction.
Yes, they said so, my lord.
Then why didn't you stop the construction that time?
Because we were not present, so I cannot make any statement as of now. But my...
This is your building in the picture.
Your worship.
Can I?
What to do then?
So my humble submission, my lord. Number one, this attendance meeting which the state respondent has relied on as per my instruction, the Rangbashno or the headman of Kletershi has never attended this meeting. That is number one. Number two, my lord, this notification which the district council has published for all the people to apply for this building permission is published on 15 April 2021. Now what I mean to say here, my lord, is that I started construction of the house in September 2020. Now all the rules which was framed by the government, even this notification came only after 2021. The
Okay,
notice...
stop there. Mr. Nagpur, who's the implementing authority? You're bound by bylaws only. Same bylaws, right?
Same bylaws.
Yes. Where's the compounding clause? Any compounding clause there?
In the 1974 provision, there's a compounding clause. In the 1974 regulation.
Or how many buildings are in violation of 50 meters?
As per the list provided.
No, Meghalaya building bylaws, there's compounding.
Yes, my lord, there is.
But can these kinds of infractions be compounded?
But those are compounding where there is a violation of the building permission.
Building permission, yes. I'm talking other compounding about other, because this is the NGT thing.
But the order of the NGT, my lord, is not directly on us, directing us not to construct the house. And the 50 meters
That is
distance
why
also...
that is why Mr. Shongwan, this court trying to find it. Otherwise, you have to go to Delhi and file your petition on Calcutta East Zone. We will see if we have no jurisdiction. Since what has happened is flows from orders to NGT, Deputy Commissioners acted, given you notice. Notwithstanding, they also have been parties also.
But they have acted very belatedly, my lord.
Doesn't
Now,
matter.
tell me as I have violated the rules, my lord, the rules must have been in place at the time when I started the construction. But that happened belatedly, my lord.
We can't, what do you call, usurp kind of jurisdiction if it stems from the order of NGT, that's the thing.
But here is the violation of my rights.
This is Mr. Sajid Lalu's case. Is still alive or is closed?
It's closed, my lord. Dispose of. Dispose.
I'll take it, sir. I'm not aware. I didn't check that.
Cases, I remember because this is doing at the time when I think I was still practice. So we were aware of these NGT matters. I used to attend capital E-zone also. Not in this case, but in other matters. It's closed.
No, the Sajid Lalu case is closed, but there's a contempt they filed. Contempt is pending in the NGT matter.
You're doing it?
No, I'm not doing it because some connected matters I'm doing that.
There are two matters, right? Sajid Lalu, he filed two matters with Mitru. If I remember correctly.
One of the matters pertaining to the river, I think this is the same one.
And the other one?
The other one, I'm not very aware, Madam, but the one that has to do with the 50 meters or this, what do you call this, catchment area. That contempt has been filed in that.
I think, Mr. Chairman, you have to seek, isn't the E-zone is before the Delhi?
Calcutta village.
Calcutta bench.
Not sure.
You can do it virtually also.
Not sure. Because not here, there are two issues. One is who do we take permission from? That's besides the point. The more important point is the direction of the NGT. With regard to the distance.
Yeah, the direction of the NGT, my lord, is the state respondents. Now, contempt, I am sure that it has been filed against the state, not against us, my lord.
That's why contempt is a state. Doesn't
Yes.
count bulldoze all the houses.
Because
if you're going to comply with orders NGT,
because
that's why you're going to save your building.
No. Here, my lord, it is not the failure on our part, but it is the failure of the state respondents
See,
only.
Mr. Shongwan, I understand. We appreciate that you're, using your advocacy skills to, to like sidestep the entire issue. But the core issue is that NGT is given orders 50 meters. And that's all. And in fact, courts like the High Court is to see that NGT orders also are implemented.
Yes, my lord.
In the right spirit and perspective. So we can't really interfere in your case. You take a call. I don't think you'd get demolished now. Otherwise, at least before this bench, it'll be a bit difficult. That's a tentative view.
Yes, here, my lord, the right has been violated.
Rights?
Now, your lordship is
Rights
exercising 226.
Okay, I'll just put a question.
Because
I'll put a question,
my lord,
to you. Suppose what I'm meant to do, was a living person, and it came. Suppose you're a judge. It came before you with petitions against that. Its right has been violated. Do you think anyone have anything to say against that? Suppose the river what I'm through was a person, was a living person, a legal personality, which could maybe fight for his own rights. Suppose it came on 226 and said, I'm the river and this is what's being done to me. Do you think any of us will have even one word to say? For that matter, any river, any forest, suppose there was a living thing that could speak. As like, you used to think about it. That
I understand.
The thing, it was a river, if it could speak, if it could fight for its own rights, does anyone can say anything, what you have done to it?
No, I understand, my lord, but
it's like that. So you have to look from that perspective also. It's not only of human needs and humans, exertions and exploitation of the land.
But the failure of the state respondents, my lord, cannot be.
Failure, that is all technicalities. And technically you have to beat,
but
you have to go for the correct forum.
Yes, but I have been made to suffer, my lord.
Not before this court. In this matter, I can dispose very simply. Since the order issued, impugn order, issued by the Deputy Commissioner, is in pursuance and furtherance to the NGT prohibiting 50 meters construction from the riverside.
50 meters was never prescribed by the NGT.
Yes, okay, whatever it is, that is 50 meters. So like you seek a remedy there before the NGT, that's all. You take your call. And you can hold them up, you can hold them up at HDC and all, for not going ahead with the, as per the mandate of the law, building bylaws, having been invested with the power, not exercising the, refuse to you exercise the power, so.
No, I'm before your lordship only on the point that.
No, that is what, so
no, I understand.
I will not interfere because that's the thing.
Because my legal right here has been violated.
Call, Mr. SN has produced a communication indicating the fact that a joint inspection of these encroachments of Mithi River was conducted on 35/2022 in the presence of Deputy Commissioner, the EAC, Town Planning Officer, forest officials, and also GHEDC. The same taken on board and made part of the record. Stop. Next paragraph. From what has been gathered in the course of this case, it can be seen that the Giant Hill Township Council has also been notified as the authority for implementing the Meghalaya building bylaws, such as in the area in question in the instant case, which is outside the Joai master plan area. Ms. L. Chongwan prays that the matter with the applications enable him to obtain necessary instructions, further instructions. Otherwise,
I'm confident that the tribunal will also take a sympathetic view to their case if they file it.
Naturally, that is why I'm saying you have a small homestead. You make your case more appealing. It's not the industry, polluting industry or something.
I was hoping more from this honorable court, my lord.
We all live on hope.
NGT. Highly obliged.
Obliged.
Yes, no one from other side. You sought adjournment earlier?
No, sir, I've already taken the consent, Lordship.
After vacation?
After vacation.
Yes.
Really obliged.
2 weeks after vacation.
24.
Wait, please, Your Lordship.
This Yarana Khalkmar is a police officer?
He is a police officer. He's posted here also, my lord, as
I was wondering, name is familiar.
My lord, in this case, what has happened, my lord? My father purchased a plot of land in the year 1988. My lord, thereafter, after he passed away, my lord, after he purchased the plot of land, he also sold a portion of the land after some time. And in the year 2011, he passed away. My mother, being the class 1 heir, stepped into the shoes. And thereafter, my lord, after my mother passed away, 3 siblings, 3 of us, we stepped into the shoes of our late mother and father. Well, in this plot of land, my lord, there was some encroachment. So we approached the civil court. After we approached the civil court, my lord, decree was in our favor. The suit initially was contested, but subsequently, my lord, the defendant did not contest the suit. In fact, a petition was also filed. If I'll take, my lord, to page 49 of this writ petition, my lord. Paragraph 17, my lord, I'll just read out. The performer defendant in the instant case had filed petition number so-and-so, dated so-and-so, stating that they will not contest the suit and that the existing school will be shifted outside the disputed plot immediately after the annual examination 2017 and that the existing structure will be dismantled and removed, including all materials during the winter vacation and forthcoming session, that is 2008, will be run outside the disputed plot. The next paragraph, my lord, the suit proceeded ex parte against the defendants as reflected white order dated 19/10/2018. Thereafter, the suit proceeded ex parte against the defendants as reflected white order dated such and such. The suit was decreed in my favor, my lord. I obtained a degree. Thereafter, my lord, we wanted to sell the plot of land. So we entered into an agreement to sell with a third party. And subsequently, my lord, we realized that the property was not registered in our name. On the strength of the degree of declaration, we approached the office of the sub-registrar, the state respondents herein. And we wanted to register the land. So, my lord, the sub-registrar said that you'll have to obtain certain documents, which included an NOC from the Dorwar. So, he said, fair enough. We approached the Dorwar. We approached the Dorwar and asked for a NOC. Now, my lord, the Dorwar says that in order to give an NOC, you get the first original 1988 sale deed, which is not in my possession, my lord, for whatever reasons. I do have a copy of it. Now, my lord, the state in the affidavit states that, my lord, because I do not possess an NOC, under Section 21 of the Registration Act, this plot of land cannot be registered. And in fact, my lord, in the affidavit filed by the Dorbar has the audacity to write to the sub-registrar saying that do not register this property because, I mean, I am the ultimate authority. Even if you have a degree from the court, that is nothing. So, my lord, that is my limited grievance over here, my lord. I say that, my lord, I am the rightful owner of the land by virtue of, stepping into the shoes of my late father and mother. We three siblings have the right to register the property, and thereafter, even if you wish to sell the property, my lord, it is within our right, legal right to sell the property. And also, my lord, in the affidavit filed before this court, my lord, certain forged documents have also been given, my lord, by the respondent number 6, my lord, very clearly, my lord, even when we look at it with the naked eye also, my lord, if lordship will come to page 21 of the affidavit filed by respondent number 6.
Go a bit slow.
I'm sorry, my lord. Well, here, my lord, another aspect of the matter is, my lord, in the
Number
affidavit
6.
Filed by respondent number 6. If lordship will see page 21, my lord, this particular document, my lord, is clearly a forged signature of my late father. If I can point out in the other documents annexed in the writ petition also, my lord, page 21.
21
of the affidavit filed by, I'm sorry, my lord, the respondent number 6, my lord, respondent number 6. The type copy is at the next page, my lord.
Yes.
So, my lord, here, my lord, a forged document has also been submitted in an affidavit, my lord, which amounts to contempt of the court, my lord. Very clearly, my lord, if lordship will see the other documents where, my lord, I have given my signature before the authorities, my lord, this is not my signature. Well, of course, I have other legal remedies to pursue for this, my lord, filing a forged document in court. But, my lord, my limited case here is that, my lord, I am entitled to register my plot of land, and when I have a decree from a, my lord, from a civil court, my lord, I think the local authorities have no right on insisting that I get an NOC from them. In fact, my lord, I have.
The land now?
I'm sorry, my lord.
Who's in possession of the land now?
We are in possession, my lord. Now we are in possession.
How do you see it as a forged document?
My lord, I will just take lordship to lordship will come to page 25, my lord.
Of the affidavit?
Of the writ petition, my lord.
You are appearing for number 6, Mr. Yuban.
No, my lord. 5. 5.
You forged a document?
But very clearly, if we look at annexure 3 from page 23 onwards. Page 23 onwards, my lord, this is
of your affidavit.
Of my writ petition, my lord.
Yes.
Till page 27, my lord, I have signed, my late father has signed on every single page. This clearly is a forged signature, my lord, on a very, even in look, the cursory glance also, lordship will be able to make out, my lord, this is a forged signature. On the basis of which they say that I have ceased to make, my late father had ceased to make any claim over the landed property.
Who's appearing for 6? You're the one who said that. Or who's the one who said that we don't, that you're not accepting substitute?
My learned friend is there.
Respondent of it's not that what my lord here, my lord, what my listening to what my friend is submitting, my lord. Surely it's a case of a disputed question of facts. Now it is becoming. Now the right.
So you have to seek a declaration that your deed declaration that deed declaration be registered.
No, my lord. Now, my lord, my lord, may kindly see at my. Can I draw my lord's attention to the supplementary affidavit filed by me, my lord? That is dated 26 September 2024, my lord. my lord. May I, my lord, as well?
26 September.
26 September 2014 to 24, my lord. This is an affidavit filed by respondent number 5, Headman Dorbash Nongrim Nongladao, my lord. My lord, may I read paragraph? At the very outset, the deponent begs to tender an unconditional apology for the letter dated 29/11/2023. It is humbly submitted that the said letter does not have an intention to undermine the rule of law or undermine the powers of authorities. The deponent regrets for choosing a words or phrases which otherwise could have been toned down and conveyed the message on the ground realities as to why the Dorbar have been insisting the original sale deed from the petitioner, my lord. Now, my lord, the petitioner has in a very plain word apprised my lord, submitted before my lord. But, my lord, there was a very murkier situations, my lord. The petitioner, my lord, by use of force has even, my lord, brought a lady police even to evict people from that plot of land, to that extent of evicting the school also, my lord, which was in that plot of land, my lord. So, therefore, my lord, there was some kind of
document that he showed that
yes.
said that 2017 exams were over, they removed the school.
My lord, that was who's under who, because the Dorbar was not a party to the suit, my lord. In fact, if my lord will see to the suit, my lord, page 44 of the writ petition, no need to turn, I'll just read who are the parties in that one, my lord. It says that title suit number 030727, which my lord, which my friend has said, and it was an ex parte degree. There was a lady called Jaltimai Teron and Paul S. Teron, and also the Nongrim Nongladao. So only 3 parties were there, my lord. The Presbyterian school, my lord. Dorbar was not a party to that suit also, my lord. But the Dorbar knows, my lord.
School belongs to whom?
School belongs to Nongrim Nongladao Presbyterian LP School. It's a managing, it's not a, it's by the name of Nongrim Nongladao Presbyterian LP School, my lord. It belongs to a mission, my lord.
Not to the village.
Not to the village, it belongs to the mission, my lord. So, coming back to what I was just, why this is the reason why we were insisting upon them. We are not a party to the suit. And this suit has been decreed ex parte. We do not know. So therefore, my lord, this is our reason why we have been insisting. That the answering respondent would humbly beg to state the following factual aspect as to why the Dorbar have been insisting on the production of the original sale deed for the following reasons. Number 1, because the Meghalaya Industrial Development Corporation Limited, via their letter dated 06/04/2022, have requested the Dorbar to demarcate the boundary of the land property claiming that the land has been mortgaged by one late R.H. Blah to MIDC. Now this late R.H. Blah is the same person where my friend just made a mention that his predecessor have sold a plot of land to somebody. So to my instruction, my lord, R.H. Blah is that person, my lord. Late R.H. Blah.
He sold the property R.H. Blah.
Yes, yes. His
father.
Portion of the property.
Portion of
acknowledged by the Dorbar that time.
Yes. Now that is one thing. Number 2, because of the strength of the mortgage, MIDC is also claiming ownership on the same plot of land claimed by the petitioner. MIDC was never a party in the suit filed by them. Now MIDC keeps on writing letter to us. Please demarcate the land. Under these circumstances, my lord, and here he is using muscle power. Another side, MIDC keeps on writing letter to us. Another side, the registrar writes a letter to us. So we were in a corner with whom to do. So under that pressure, my lord, we wrote what letter we have to write, which we apologize, my lord, which should not have been written. But the factual scenario is this, because this is the reason why we have been insisting, my lord. This is the reason, my lord. So therefore, my lord.
Original seal deeds where?
I'm sorry, my lord.
You have a copy, you said?
My lord, I have annexed a copy of the first seal.
So when you sold that land to your father's R.H. Blah, it was not properly demarcated, the schedule?
It was, my lord, it was. Lordship, I'll take lordship to the...
Where's the seal deed?
Page 17, my lord. 17 is the type copy, 18 is the original copy.
Oh, this deed of sale.
Yes, my lord. This is the Kacha seal in the year 1988.
No, this is the one you bought originally.
I initially
bought. Where's the other seal to that black?
Well, 1 second, my lord. Page 23, my lord.
So here the schedule is there. So what's the problem?
Everything is there, my lord. In fact, my lord, they are privy to the fact that I purchased the property initially, then I sold a portion of the property. Well, everything has been under their knowledge. Now, by filing this additional affidavit, supplementary affidavit, he cannot bring new. My lord, he cannot say that MIDC wants to claim the property, and my learned friend is not the court to decide. There is already a court which has decided.
One thing, see the schedule of the original land. The area is not given. Conduct fair. Okay, you bought 1988.
88.
Okay. So then he made a declaration on this plot of land.
My lord.
That is Adventist Record Sub Registry.
My lord.
Where's the schedule? Same schedule. The area is not given anywhere.
Well, area is there, my lord.
How is it only 8,515 square feet?
My lord.
It's a very small piece of land.
It's not a very huge land, my lord. Even the same schedule is there in the degree also.
I just did not follow, my lord. Which
square meter, my lord, not square feet.
You look at page 20, it's written square feet.
Page 20.
Well, I think this is a typographical error, my lord. The original will be at page 22, my lord.
See, even this one, that is totally wrong. I mean, you know how.
But my lord, the same schedule is also there in the.
Whatever it is, you can't. This is a typo. Yes.
Well, my learned friend's contention that MIDC is laying claim over the land. Well, for that, well, MIDC can go to court. My only limited prayer before this court is, my lord, I want to register the land, and my lord, I am without the NOC because I have made an attempt to get the NOC, and my lord, for no reason, my lord, on very flimsy grounds, my application for giving me NOC has been rejected. They are not giving me the NOC.
Now,
and this, my lord, this Kacha seal deed of 1988.
Yes, now that means this land originally 8517
square meter.
That'll be around 2 acres, less than 2 acres. 8517
more or less. More or less.
85,000 square feet, right?
My lord.
So you sold 2,200 square meters here.
My lord.
Out of 8517.
Means 22,000 square feet.
Yes, he's left with, around 6,000 something. If he sold 8517 or 8517 he bought, he sold 2200, right?
My lord, that is.
So he'll have 6317. That means 6317.
No, my lord, initially, my lord, when the property was purchased, my lord, there is no such demarcation about the measurement of land. The property is known as, my lord, given by a particular name.
You understand, but I think
subsequently after it was sold.
There, where it's registered,
my lord.
And also the area has been given correct. It is scheduled.
My lord.
So you have to go by receipt document only.
Yes, sir.
So then the entitled. Then where's your draft deed declaration? Page.
My lord, Well, initially I had prepared a DOD which was only notarized, my lord.
Where is that?
Page 98, my lord. Here the actual
98.
Page 98 of the writ petition. my lord.
See, Mr. Yubin,
My lord.
page 102 it mentions the land of Arbala, if that's been mortgaged to this MIDC. This is a question is seeing deed declaration for 8517.
So, 7 was sold to.
But this is stamped. How come? This deed is annexed.
No, my lord, because thereafter, my lord, we registered an agreement for sale before the sub-registrar. So this was annexed to the agreement for sale. So that is why, my lord, the seal of the sub-registrar is there.
This is the agreement for sale.
My lord, yes. This is a part of the agreement for sale, my lord, which is at page 86, my lord.
So you entered agreement for sale.
My lord.
Then you wanted to take a deed of declaration.
My lord, because at that point of time, my lord, it was only a notarized deed of declaration. Then the petitioner realized that he has to register the property first. Only then he can enter into a sale with this third party.
Where's your deed of declaration notarized copy?
Well, this is the one, my lord, which I've initially notarized, my lord. Subsequent to that, my lord. I'm sorry, my lord. 90. Yes, my lord.
It is the agreement for sale.
Well, in page
21,
98, my lord.
21, there is one deed of declaration. Page 21.
That's a different one. Well, what lordship is asking is, my lord, page 86 is the agreement for sale. Along with the agreement for sale, I made an.
Where's the draft deed of declaration?
My lord, my lord, when I went before the sub-registrar, my lord, I wanted to register. When I asked for what are the requirements, my lord, then I was told that you need to bring all these things. So, my lord, I could not produce the draft before the sub-registrar, my lord. Because
So
only
this draft was annexed, this notarized one.
Well, this
and was stamped during the agreement of sale.
Yes, my lord.
That's why it's stamped. Okay.
That is why, my lord, the confusion is because, my lord, after this was produced, my lord, we came to a realization that the property has to be registered. So I have to go before the sub-registrar and produce a deed of declaration which will be registered over there. Subsequent to which I can, my lord, sell the property. And that is when, my lord, I was told to get the list of documents were given to me. Well, I was in possession of everything except for the NOC. So I approached the Dorbar. The Dorbar called me. I went there, my lord. Thereafter, they did not give it to me. They are on flimsy grounds saying that I need to obtain the first original sale deed, which is not in my possession.
Even page 21 deed of declaration, my lord, this brings lots of doubt, my lord, because a person when he's still alive, my lord, and he's not saying that the normal practice, what we do is that if my father dies without intestate, then I declare that I am the legal I'm the legal heir, and these are my father's property, therefore I submit my deed of declaration. Here a person is still alive and he submits a deed of declaration.
Is still alive, the person?
Yes, my lord. At that point of time, Hoster ding dong, my lord.
Yeah, my lord, even if I am alive, my lord, at that point of time, the reason, well, I'll explain why.
No, you can do, why, what do you mean you can make deed of declaration? You can make, suppose it's given by the Shinong or something, you can make.
No, you always make, we do that every now and then, my lord. Nothing wrong with it. It's not that I have to die to.
If you succeed and testate within your family, then yes, maybe some instrument is not registered. Then, but what do you mean to say that he can't make deed declaration for properties like that?
There's nothing written in there, but the practice that we normally do, my lord.
From this lady, but then he should have registered the sale deed.
He did not register that.
But the lady had died.
No, my lord, she was alive.
The one that Tehran sold to you?
Yes, yes, yes.
Then how do you make declaration then?
That's what I'm pointing
out.
Was
it registered?
It is registered, my lord. Rightly or wrongly, that point of time, maybe he was not. He should have otherwise made a seal deed. This entire controversy would not have been there, my lord.
Yeah.
But my lord, my only prayer before this court is, my lord, whether my learned friend can insist that I produce documents before him. That, my lord, his NOC is vital for me to register my property. And the state takes the aid of Section 21 of the Registration Act, well, which I think is misplaced, my lord, it's totally wrong. My lord, the state in its affidavit says that, my lord, under Section 21 of the Registration Act, my lord, NOC is mandatory, which I believe is absolutely wrong. My lord. So, my lord, my only case is...
Who's applying for the state?
Your Lordship, first of all, Your Lordship, they had entered into an agreement for sale without legally transferring the land to their name, Your Lordship. Now,
Okay,
that I can...
That's a lapse on their part, but they're correcting, yes.
Yes, Your Lordship. And, Your Lordship, the entire thing is premature, Your Lordship, in the sense that they have not even filed or executed. They have just inquired what are the documents required, which we had informed them that an NOC is one of the vital document that is required, Your Lordship, to prevent any
Where's the
future
affidavit?
disputes.
124.
Yes, Your Lordship. Just to prevent any future disputes, Your Lordship.
Filed on 7th of June.
Yes, Your Lordship.
But there's, see, Mr. Gautam, that way also there's the inbuilt mechanism. Which is
Absolutely.
You put it for a registrar registering. If they reject it, it goes to registrar.
Yes,
and
it is, well,
you're
it is...
seeing a preemptive strike that, like, so that you get a vandalism from the
My lord, it has already been rejected, my lord, because,
Your
my lord,
Lordship,
when
they
we...
can file,
when
Your
we
Lordship, they can file, then a hearing can
well, if she
be...
says that, my lord, that they will allow... My lord,
I'm not saying that we will allow, Your Lordship. I'm saying that they can file, Your
My lord, this
Lordship, and then we
is-
can call for hearing, Your Lordship. It can be heard.
my lord, when we go to register a particular property, my lord, nowadays, I'll explain to my learned friend, my lord, we are given a certain, first of all, how much stamp duty is to be paid, and what are the requisite documents. Now, my lord, in the absence of the requisite documents, my lord, no person can go and prepare a deed or a
You
seal
think
deed.
so? Is that possible? You prepare and
Yes,
present
Your
for
Lordship, we
registration.
prepare and we file,
If
Your
sometimes
Lordship.
reject to pass reason order.
So, my lord,
then
dire-
against that,
a-
you go and appeal registrar.
a
and
direction-
after registrar
Yes, Your
rejects, if they do
My lord,
reason order, then
only
you
in
come
that
to
case,
the
my lord, a
court.
direction may be given. Then, my lord, my if there is a
Yes, let
legal
them examine
this,
it.
Yes, Your Lordship. Then...
fair
all the
enough, once
parties
they
can be
give a
heard, Your Lordship.
Yes. MS
no,
Yatham.
no objection on rejection on flimsy grounds by the sub registrar.
Yes. Anything to say? You are for the Shnong.
For the right, my lord. Lengdo right.
You have nothing to say.
Application I have submitted the forged documents, Your Lordship. Your Lordship, I have stated in paragraph number 4 of my affidavit in opposition that I have been appointed and succeeded as the lender of right Wailasa on 14 June 2022. So, Your Lordship, the documents which I have submitted, it is the document which was available from the office,
Record.
From the office record. So, it was maintained by the then law who has been expired.
Okay. And take down then, yes. How many petitioners are here? Other ones didn't come.
No, my lord.
Sort of registered in 3 names, correct?
My lord, but my lord, they are my siblings, my lord.
Doesn't matter. Anyway, the writ petitioner is before this court with a prayer that the deed of declaration which the petitioner and his siblings seek to execute be directed to be registered within a reasonable period of time. the reason as made out for approaching this court at the initial stage, where's the reason he said? NOC, where's that?
My lord, page 124. This is what I was asked by the state respondent, my lord.
Due to the fact that 124.
My lord, 124, serial number 5.
Due to the fact that the registration authority, that is respondent number
124. 124. Sub-registrar is respondent number
114. Where's the thing? Page?
My lord,
124.
Sub-registrar is number 4, my lord. State is 124, sub-registrar is
Number 4. Tom, no? Has also has in the list wherein the documents required for deed verification been given requires requires a serial number 5 or requires an NOC from the headman stroke Imraj stroke Sadaship bracket 2 copies or Sadaship finish, which the petitioner is not in possession of. Stop. Next paragraph. Mr. K. C. H. Gautam, learned counsel for the petitioner, submits that the issue in question submits that the NOC as required on application from the headman, correct? Respondent number 5 could not be obtained inasmuch as the original sale deed which had been executed by his father, his predecessor interest with the vendor on which date?
12/4/1988.
12/4/1988 is not his possession apart from a photocopy thereof. He further submits that as the said NOC is not available, the writ petitioner has been compelled to approach this court to allow the writ petitioner to present the deed declaration for necessary registration stuff. Next paragraph. MS Ailingwa Leonard GA on behalf of the response 1 to 4 has at the outset submitted that Registration Act submitted that the writ petition is premature in as much as the writ petitioner, in much as the petitioner has approached this court before the registration authority, before presenting the said document before registering authority, and that an assumption has been made that the same refrigerator rejected without consideration. He further submits that He first submits that for section 71.
She's taken the plea of 21, my lord.
71, huh?
21, my lord.
71.
20, my lord.
Yes?
He's taken the plea of 21, my lord.
NOC?
NOC, my lord.
We'll disregard that. Yes, she first submits that in the statute itself, that Registration Act, as section 71, if a document is refused to be registered, the sub-registrar shall record reasons therein, whereafter under section 72 provides for statutory appeal against such non-registration. She further submits what, 21? She further submits that I'm just making submission for you since you didn't submit this part. 71.
Your Lordship.
Yes?
Your Lordship, an NOC, Your Lordship, is required, Your Lordship, in every registration, Your Lordship, especially a deed of declaration, Your Lordship. Especially in a deed of declaration, you require an NOC from the surviving legal heirs, you require an NOC, Your Lordship, from...
No, because this is a different case. It's not a, anyway, just hear the order. Yes, she further submits that Section 21 also provides for proper description of property, maps of planes, maps of plans. This has no application.
Not at all.
Strike it out, yes. She therefore submits that the writ petition be, as she reiterates a submission that the writ petition being premature, the same should be rejected. Stop. Next, Mr. Yubin.
Yes, ma'am.
Next one, Mr. P. Yubin, who's present on behalf of number 4, the headman, submits that as the plot of land has a checkered history, which the village darbar is not able to discern as to the correct schedule.
Yes, my lord.
As to the area and schedule. Just recording your submissions only.
My lord.
In as much as there are third-party interests involved in the form of the MIDC, to which a portion of the land which had been sold by the predecessor interest of the writ petitioner had been mortgaged.
Yes, mortgage.
For which the village under pressure to have been mortgaged. So, it therefore submits in view of these circumstances, the NOC has not yet been granted until these facts are determined and finalized.
And one more point, my lord, is this also because P.S. Lingdo, my lord, there's a P.S. Lingdo is the wife against whom my friend's client has got an ex parte order, my lord. Now
so that view,
yes,
yes.
that will
and
that,
MS Riatham, appearing for respondents number 6, submits that whatever documents have been annexed in the affidavit for which allegations have been made as to them being fabricated is not for the knowledge of said respondent, as the documents annexed are been obtained from the records present in the office of the Sodaraj, of the Lingdo Araj. So, and after having heard the counsel of the parties, it appears that the writ petitioner has been constrained to approach this court due to the apprehending that there would be outright rejection of his application for registration of deed declaration due to unavailability of the NOC, which has given at serial number 5 of the list of documents necessary for the declaration. Stop. However, this court notes that from examination, from an examination of materials record that the property in question, which was originally held by the father of the petitioner, has its own history, which should be examined in the facts and circumstances of the case itself, especially with regard to the manner in which the same has changed hands. Stop. In this view, the matter, more so in view of the fact that the instrument stroke document is yet to be presented for registration before the responsible for, which is a competent authority to examine such matters. He has provided that the petitioner shall present the same for registration for responsible for, who shall, on consideration of all the facts and circumstances thereof, decide on the matter in accordance with law. Stop. When can you present it?
My lord, within 2 weeks, my lord, 2-3 weeks.
Mr. Kesam submits that, praise that, shall, as per submissions, present the same registration within 2 weeks from the date of this order. With as ordered above, the matter stands closed and disposed of. Because once you presented the issue notice, then they'll have a hearing.
Yes.
That's it, and then we'll go to that. If the sub-registrar feels that there's no reason why it really needs one. They have the power to make inquiry also. Registrar to have the power to make inquiry also.
Yeah, they can. We
Especially
have everything.
suppose
We have everything except
persons who are, who are concerned in entire transaction. They have the power.
Yes. Obliged.
Obliged, Lordship.
Supplementary list, item number 1.
My lord,
waiting for the
Friday, my lord, the Nehu, we have served a copy, my lord, Mr. And then to the principal, my lord, on the Friday, my lord, we made an attempt to submit. Principal have left. The office have not refused to accept. Therefore, we were delayed in coming back and filing, my lord. If my lord may kindly issue notice, we will take Dusty today itself, my lord. Let the matter come up tomorrow, my lord. Here, my lord, what happened was this, my lord. Here is the student.
Give the medical certificate.
Medical certificate, my lord. Where was it?
Showing that he's been advised rest.
My lord, the medical certificate is from page 51 onwards, my lord.
Oh, he's got gallbladder stone. That's why.
Yes, my lord. So entire August, my lord, there was a loss of pain, so he did not attend. Finally,
but then Nehu can't do anything. They have to go on the recommendation of the college itself.
Principal, my lord. Principal, my lord.
Other day, Lordship, affiliated college, nothing in our hand.
Yes, my lord. Because
yes, take down. Heard Mr. P. Yobin, then we consult with the petitioner. Issue notice. Mr. S.N. Principal is present on behalf of the respondents 1, 2, and 3. No further is called for. Notice to issue by to respondent number 4. And the resolution of stop. The writ petitioner is a student studying in
5th semester, my lord.
Currently studying in the 5th semester LLB course.
Yes, my lord.
At
Shillong Law College.
Shillong Law College, bracket respondent number 4. Number 4. Stop. Number 4. And for comments here, a prayer to allow the petitioner or to issue direction to allow the petitioner to consider directions to direct respondents, especially 104, to consider application of petitioner to condone a shortage of attendance, which according to him, which was caused to illness. Stop. Next paragraph. Mr. SN submits that as this part of the issue has to be from the affiliated college itself. The university at this stage will have no submissions to make. Next paragraph. Accordingly, Mr. Guyubin to effect notice, personal service of notice on 104 by today itself.
Yes,
as the exams are due from?
6th, my lord,
from
Friday.
December. This is the matter tomorrow.
Tomorrow.
My lord.
You
get a thing? But then, how many days he is absent?
My lord, he has got a 60% attendance, my lord.
He needs 75.
He need, as per the BCI rules, my lord, 70, my lord. And the principal under exceptional cases can condone, my lord. Can condone. And then he has got very genial.
Have they rejected the
yes, my lord.
application?
Yes, my lord. He has.
Where the rejection?
There's no rejection order, my lord. But he has not been allowed to submit his exam applications, my lord. Okay. No order has been passed, my lord. Obliged.